The International Labour Organization is implementing the European Union-funded project towards safe, healthy and declared work in Ukraine. What does the project do? The project helps to approximate national legislation to the international and European labour standards, trains Ukrainian experts on labour relations, occupational safety and health and labour inspection, explains to employees and employers why it is important to declare employment relationships. Thanks to the project, Ukraine will be able 1. To improve safety and health at work, to lower the number of work-related accidents and occupational diseases. 2. To reduce undeclared work, so that employees are declared in line with the law, are socially protected, and employers have motivated teams. 3. To improve the effectiveness and efficiency of labor inspection, so that laws are complied with. Moving forward together towards safe, healthy and declared work in Ukraine.
So, good morning, dear colleagues. If I may, let me make a short introduction for those who have joined online on Zoom. You have just seen a short video about our project, just to remind you about who we are, why we're here, and what our objective is in Ukraine. So, if you are with us online, I ask you to activate your video and to be present here with your faces so that we could see that you are interested, engaged. Yuri, I welcome you. You are in the tunnel of love, I see. Okay, so that we could see you and knew that you are here and not just listening to us as radio. So we have two working languages today, so it is important for you to arrange the language channel properly, so you can see the glow button on Zoom, and there you need to choose the Ukrainian channel, and then you will hear our national speakers in the original, while if the experts speak in English, you will hear the interpreter. So it's very important that you keep yourself muted, not to create extra noise. And according to the program, the first part before coffee break, there we will have a presentation of the experts who came up with the technical recommendations. During that time, your microphones will be off, but in the course of that, you may have questions. Please write those questions in the chat box. We will register them, and then we will ask them to the expert when we have Q&A session. And also, when during Q&A you have questions, you have this reaction function on Zoom panel, and there you have a raise hand button. Then we will see, if you push it, we will see that you've risen your hand, and we will pass the floor to you. Or even better, write your questions in the chat box. But again, let's start every question with the code word question. Then I will be able to keep track of your questions. So welcome. I see people welcome us in the chat. For those who work offline, that will be easier. Your advantage is that you will have real coffee, while for the colleagues on Zoom, it will be virtual coffee. So now let's switch to our agenda, and I pass the floor to Antonia Santos, project manager.
Good morning, everybody. Thank you for joining us. I can see that we have around 42 people online, plus we have around 16 people here at the conference room. So thank you so much for jumping in. First of all, let me tell you that we have among us representatives of the State Labor Service of Ukraine, representatives of the Minister of Economy, representatives of trade unions, representatives of employers' organizations, and also representatives of the Ukrainian Association of OSH experts. Thank you for coming. The objective of this workshop is to discuss the SLS draft legal act on transposing the EU directive on the minimum safety and health requirements for temporary or mobile construction sites. This is very important because, as you know, Ukraine committed to align national legislation on OSH with the European Union acquis. And the European Union acquis is not just composed by the EU WASH Framework Directive 89391. That is the mother directive. But beneath that, that mother directive, flesh out a series of other directives which are focused on specific issues of WASH, either in terms of specific risks like chemicals, like biological risks, musculoskeletal disorders, whatever, and also focus on specific sectors of activity. And this is one of those directives focused on specific sectors of activity. In this case, temporary or mobile construction sites. So Ukraine should have in the near future an architecture of legislation on WASH which is equivalent to the one that exists in EU. And it's not just one directive, it's a set of interrelated directives. You should keep that in mind. That's why it's so important. They talk all to each other. And you can see on this directive refers to the directive on safety and health signs, for example, or to the PPEs, for example. So, and also another important aspect is that the EU Framework Directive always apply to any situation if the given directive is not more stringent or specific in determine in a given aspect. So they all talk to each other, and they are all subjected to the general prescriptions of the EU Framework Directive. So we have with us today Pedro Brás. Pedro Brás was the international expert that drafted the technical recommendations on behalf of the ILO regarding the State Labor Service draft law to transpose the directive on temporary and mobile construction sites. Let me just tell you a few words about Pedro Brás. I know him for several years now. He is labor inspector of the Portuguese Labor Inspectorate for since '96. He was already Inspector General of Agriculture in Portugal and also Inspector General of the Portuguese Labor Inspectorate. He was also the head of the MASHEX group in the European Commission SLEEC. SLEEC stands for Senior Labor Inspector Committee, which is a committee of experts that represent the senior labor inspectors of each country of EU, and they organize their work in work groups. And Pedro was head of the MASHEX group, which is the work group that deals with the machines directive and with the work equipment directive. So he's someone that knows a lot about occupational safety and health, especially in construction, and in general also is very knowledgeable on labor inspection and labor legislation. So with no further delays, I would give the floor to Pedro Brás. He will present the main aspects of the technical recommendation that he provided. Then we'll have a coffee break, and SLS will have the floor to put a series of questions that they have regarding the alignment of this draft law with the construction site directive. And then we will open the floor to everybody to put their questions, and Pedro will try to respond to them. So I will pass the floor to Pedro and wish you a very fruitful discussion. Thank you. You have the floor, Pedro. Thank you.
Good morning. Thank you very much. First of all, I would like to start by greeting everyone present, especially social partners, members of the Ukrainian government, the Ukrainian Labor Administration, health and safety technicians of Ukraine, and thank you very much for standing here with us, with me. I want to thank the ILO for inviting me in the person of my dearest friend, Antonio Santos, to develop this work and to share some of my humble experience with you. I'm very sorry that I was not able to take this opportunity to get to know Kiev and Ukrainian, but of course, public health is far above these trivial professional and cultural purposes. Slide number 2, please. I will excuse myself from not doing all the entire framework in which this work is inserted because everyone knows the reason why it was carried out. However, I advance that these technical recommendations are intended to promote a better alignment of the State Labor Service of Ukraine, draft legal act of the minimum worker safety and health requirements for temporary or mobile construction sites, with the main applicable international and European labor standards and best practices. In particular, with ILO Conventions 187, 155, 161, 81, and 129. Most especially with the EU Council Directive 391, the Framework Directive, on the introduction of measures to encourage improvements in the safety and health of workers at work, and of course, the Council Directive 57 of 24 June 1992 on the implementation of minimum safety and health requirements at temporary or mobile construction sites. It's the 8th individual directive within the meaning of the Article 16 of the Framework Directive 391. Slide number 3, please. The work is structured in 3 chapters: main positive aspects, key aspects to improve, and the detailed recommendations. In this presentation, I will focus only on the first 2, because common sense advises me not to expose all the recommendations in this presentation due to their thoroughness and detail. So I will stick to the most important ones. Of course, all the detailed recommendations are contained in the document that was delivered. Slide number 4. Let's start with the most important positive aspects. As most important positive aspects of the document of the SLS of Ukraine, I would like to highlight the development of a modern legal regulation, aligning national legislation with the applicable international and European labor standards and best practices in the area of safety and health requirements at temporary or mobile construction sites. It reflects a more goal-oriented and organizational preventive approach, as requested by the EU Council Directive, Framework Directive 391, and ILO Conventions number 187 and 155. Shifts from an approach based on protection, correction, and compensation to an approach focused on prevention and foreseeing the general principles of prevention, general principles of prevention, GPP, applied to construction sites, including the employer's obligation to assess and control the occupational risks. Incorporates the 2 fundamental pillars of the Directive 57 on mobile construction sites. The first one applies the philosophy enshrined in the general principles of prevention to the act of designing the building, namely in terms of architectural options and technical choices of materials. Second pillar strengthens coordination between the different stakeholders from the preparation of the project of the work and also during the execution of this work, of the same work, in order to streamline the articulation and succession of interventions, considering the different requirements for planning, safety, and health at work. It's a system. Slide number 5, please. Perceives the client, the owner, as the first level of decision of responsibility and as who generates all the subsequent chains of responsibilities. And this is a fundamental aspects. The owner, the client, has the number one responsible for all the things that happen in the construction site. Realize the existence of an integrated occupational safety and health coordination system in which the safety and health coordinators assume a key mission. Underlines the importance of safety and health planning through the prior notification of the opening of a construction site and the safety and health plan, which emerge as the main prevention tools and coordination instruments. The distribution of responsibilities among the different stakeholders was well perceived and recognized as a function of the role they play. Their ability to intervene and influence in each of the stages of the construction process, and the impact that the options taken by have on the nature of the resulting occupational risks. Responsibilities are therefore properly distributed between the client, the project supervisor, designer, general contractor, and self-employed persons. Slide number 6, please. Now let's move on to the main aspects to improve. As I mentioned before, I will not cover all these aspects in detail, but only the main ones as examples. This normative act or legal instrument, in my opinion, should assume the typology of at least a cabinet of ministers of Ukraine decree or resolution, CMU, instead of an order of the Ministry of Social Policy or of the Ministry of the Economy. Not only to ensure the necessary legal power for a higher hierarchical law, thus rolling out other legal diplomas on the same matters that already could exist, but also to ensure the stability of the legal framework, enabling, as a result, greater legal certainty. Besides, a directive is a text with general application in all EU countries, and by so, its implementation should adopt a legally equivalent instrument. The choice of a higher hierarchical legislative act is adopted by all EU member states, as showed the assessment carried out in 2004 by the European Commission. The legal instrument must have the necessary legal power to ensure its effective implementation, overcoming contrary provisions of existing legal acts, as well as to safeguard its sustainability and perennially, which are needed to ensure the certainty and security of legal system, as previously recommended. It is also about the consistency of the reform of OSH legislation in its internal relations, as well as with the pre-existing legal acts, using the hierarchy of laws in an appropriate way. This hierarchy of laws, it's all important to pay attention. The legal act systematic structure and clarity should be improved in order to simplify it and to facilitate its understanding and alignment with the EU Directive 57 on construction sites. Some examples. All paragraphs of the articles of the draft legal act proposed by SLES, as well all the section of the annexes, should be duly and hierarchically numbered in order to facilitate the understanding of the legal provisions and their cross-reference within the text, and most especially to facilitate its overall understanding and effective application. The definitions, legal provisions, as well as the terminology used must improve the consistency with the draft law of Ukraine, transposing the EU Directive 391, the Framework Directive. Another aspect, it's the title of the draft legal act proposed by SLES should be replaced by, in quotes, minimum safety and health requirements at temporary or mobile construction sites, end of quotes, because the safety and health requirements are not of the workers, but instead of the workers, which means of the temporary or mobile construction sites in this case. In reality, the scope of the directives, 391, the Framework Directive, and all the subsequent social directives, namely this one, 57, as well the ILO Convention 155, 187, 167, are about safety and health in workplaces. Although this Directive 57 on construction sites aims at implementing an intrinsic occupational risk prevention system at workplaces that, in fact, has workers, has final recipients, the foreseen rules are addressed and applicable to different stakeholders in the workplaces, namely client, project supervisor, coordinators for safety and health, general contractors, employers, self-employed persons, compelling them all to an effective management of safety and health of those workplaces. Having workers as final recipients, it will be reductive to name an entire architecture of professional risk prevention focusing only on them, even suggesting those workers as single actors and even, who knows, responsible for adopting the measures to be implemented. It is intended that the entire system works to ensure the safety and health of those who work in the construction sites and, of course, especially of the workers. Slide number 7, please. The draft legal act misses to insert in Section 1 general provisions, a provision which, with the reference to Article 16 of the Framework Directive 391, foresees that the provisions of the law of Ukraine on occupational safety and health of workers, which implements the provisions of the Council Directive 391, implements the Framework Directive, shall apply in full to the whole areas referred to in paragraph 1, without prejudice to more stringent and/or specific provisions foreseen in these minimum safety and health requirements at temporary or mobile construction sites. This insertion is therefore recommended as a proposed paragraph 3 of the proposed new Article 2. It was found several times that this adaptation of the Directive 57 carried out in the draft legal act proposed by SLES had clearly the intention to, I could say, innovated it, so as not to copy exactly the wording of the text of the directive. However, in my opinion, very often the results did not fully transpose what the legislator of the European Union intended to the diploma. Accordingly, with the aforesaid, there are therefore a set of expressions and technical words that are not entirely in accordance with the Directive 57. Namely, in paragraph 1, section 1, general provisions, the word engineering was missing. It was therefore added as the scope of this Directive 57 is not only the construction of buildings, but also civil engineering works. On the other hand, the words planning and coordination were also added, because these are not just rules for organizing the safety and health of a construction site. Actually, above all, these rules shape a safety and health prevention system, which encompasses the planning and coordination of the same safety and health. Example, both the prior notice to the competent authorities and the safety and health plan documents. In fact, an event can be organized, but go wrong because it was not previously planned and properly coordinated in the discussion phase. These three verbs, to plan, to organize, and to coordinate, are the key to the effectiveness of safety and health in the workplace in general terms, and in a construction site in particular. Slide number 8. Despite the fact that the Directive 57 and the draft legal act of minimum worker safety and health requirements for temporary or mobile construction sites present the list of works covered in annex, in my point of view, it seems very important that this list appears immediately in the body of the law. It makes it easier to use for the different stakeholders. It's more direct. At the same time, the excavation works were not included in the list of works of the Ukrainian draft legal act proposed by SLES, but they are part of the list of works in Annex 1 of the Directive 57. Thus, these excavation works were included because the meaning of the word earthworks, the meaning of the word earthworks, may not comprise excavation works, and these are high-risk works. In turn, the list of works is somewhat disordered which trying to specify too much can lose scope. Hence, another wording is proposed. For example, the arrangement of heat insulating facade system can be included in the alteration, fitting out, conversion, or upkeep building works, or roofing works, which are included in various construction works, namely construction, expansion, alteration, etc. What is obvious is that there is no doubt that these works fall within the scope of this law. The specification of some works may indeed lead to the exclusion of others, which are not specifically mentioned here. However, it was added the terms scaffolding, cranes, and other lifting devices, because they are listed in Annex 4, Part B, Section 2 of this directive, and most of all, because of their weight in the occupational risks of a construction site. The Directive 57 makes explicit the drilling and extraction activities, which are not included in the paragraph 4 of Section 1 general provisions. Then also it was added the word drilling in paragraph 2 of the proposal new Article 2 scope. The sentence in quotes, except works related to underground mining of ore and non-ore mineral resources, as well as construction and operation of underground mining workings created during open pit development of mineral resource deposits, end of quotes, which was contained in the original Annex 1, was removed and was not incorporated in paragraphs 1 and 2 of the proposal new Article 2 scope, because it is useless. Its meaning is already contained in the wording of paragraph 2 of the proposed new Article 2 scope. In particular, this law does not apply to drilling and extraction activities that take place within the extraction industries. Slide number 9, please. In paragraph 2 of Section 1, General Provisions, this paragraph was deleted. It is unnecessary to mention the interveners in this law, as they are clearly identifying it, as well as their responsibilities, which must, in cases of non-compliance, lead to the respective sanctions. Their involvement stems from the text of the law. This reasoning assumes that there must exist an objective accountability of the interveners existent at a construction site. With the subsequent sanctions, this accountability and sanctions are directly interlinked between themselves. Moreover, this liability and sanctions should be included in this law. In fact, the more objective and obvious this responsibility with the corresponding sanctions, the more useless it becomes to refer to the interveners in the workplace in a separate provision. More important is to ensure the coverage of all areas of all economic sectors in accordance with Article 2 of the Framework Directive 3/91. So, such coverage was added, underlining that the law should cover two whole branches of activity in the public, private, cooperative, and social sectors, to public administration, as well as to whole self-employed persons with regard to building, construction, and civil engineering works. In paragraph 5 of Section 1, general provisions, and with regard to the definition, several changes were made, but of which the safety and health plan stands out. And I want to speak about the safety and health plan. It was necessary to better specify the content of the safety and health plan, since their wording in the draft legal act proposed by SLS was somewhat confusing. According to the fourth paragraph of Article 4 of the Directive 57 on construction sites, the safety and health plan must be considered also during the various stages of designing and preparing of the work project. Therefore, these risks must be also prevented at the project stage. Pursuant to the Article 5b of the same directive, the safety and health plan must indicate the rules applicable to the construction site in question. So, as it is a safety and health plan, the rules should be ones of safety and health. Pursuant to the paragraph 2 and 3 of Article 6 of the Framework Directive 3/91, there are no preventive measures without prior identifications and assessment of the existing risks. which must cover all works from the beginning to the conclusion of the construction work without any exception. Consequently, safety and health plan should be a written document that includes a package of measures aimed at preventing occupational safety and health risks, either in the project stage and during the execution of works on a specific construction site. The safety and health plan should identify the occupational risks associated with the different phases of the construction process, of the constructive process, evaluate these same risks, and prescribe preventive measures aimed at eliminating or reducing the same occupational risks, thus contributing to ensure the safety and health of workers, including specific measures relating to the works that imply special risks to the safety and health of these same workers. In subparagraph 3 of paragraph 1 of section 11, there is an example how translations can change or constrain the application of a provision, where the wording states, in quotes, workers' representatives shall have the right to approach, I underline to approach, the employer with suggestions as regards taking appropriate preventive measures and preventing any danger for workers and or removing sources of danger, end of quote. The text was changed to, in quotes, workers' representatives have the right to ask, I want to underline have the right to ask, the employer to take the appropriate preventive measures to submit proposals for this purpose in order to mitigate the risks to the workers and or removing the sources of danger, end of quotes. This amendment was made because, as provided for in Article 11 of the Framework Directive 391, this is not just a matter of workers' representatives being able to make a simple approach to the employer, but rather of being able to make concrete proposals and ask him to take the appropriate preventive measures. The word approach does not translate what the European legislator intends. In fact, the legislator wants the workers' representatives to be able to ask the employer to take tangible measures, also presenting concrete proposals. Yet another example of non-full translations is what is in section 13, paragraph 2, on minimum requirements for on-site workplaces, arrangement of indoor workstations. In this case, the words deposit and dirt were added to replace the words substance and dust. The words deposit and dirt used in the Directive 57 have much broader meanings than the words used in the drafting of this law, substance and dust. In fact, deposits and dirt include substances and dusts, but they also encompasses, for example, mixtures which can diffuse into the atmosphere and which are neither substances nor dusts. Slide number 10, please. There is often confusion between the meaning of the words hazard and risks. By definition, as you know, hazard is different from risk. While hazard is something that can cause harm, for example, electricity, chemicals, working up a ladder, noise, a keyboard, bully at work, stress, etc. The risk is the combination of the chance, probability, high or low, that any hazard will actually cause someone harm with the gravity, high or low, of its consequences. Some corrections were made. Another confusion is between workplaces and workstations. As you know, also workplaces are wider and includes workstations, whereas the latter means individual place, station, spot, which in principle is assigned to just one person to work. To the content of the Safety and Health Plan, Section 5, has been added the information and training system for all workers present on the construction site in matters of prevention of occupational risks and the necessity of a written record of the activities of the coordinator for safety and health. In this written record of the activities for the coordinator in safety and health, it's very important. This record includes the activities of the general contractor, contractors, and self-employed persons with regard to ensuring compliance with what is determined in the Safety and Health Plan. It is essential that the coordinator for safety and health is able to prove his activities and compliance with his obligations, either to be able to prove them to the client and the project supervisor, also to the labor inspectors when necessary, or to discipline himself and discipline all employers and self-employed persons engaged on the construction site. When having to show their activities, the coordinator for safety and health will always have greater discipline in developing them systematically and in a structured way, not forgetting their mission. In section 6, the expression general provisions on workers' safety and health should be changed because in its content there are some technical provisions together with the so-called general principles of prevention, as enshrined in paragraph 2 of Article 6 of the Framework Directive 391. It is therefore important to emphasize the general principles of prevention. Moreover, the measures to be adopted are preventive measures in order to prevent the occurrence of work accidents and occupational diseases. These are not mere protective measures. They are preventive measures, non-reactive measures, adopted upstream of a possible nefarious event. That's the wording of the Directive 391, which designates all these measures as preventive. This word prevention illustrates the philosophy of the entire architecture of safety and health, both in the Framework Directive 391 and in all subsequent social directives that emanate from it, namely these 57 on construction sites. In section 7, responsibilities of the client and project supervisor, it was included that regardless of the appointment of the coordinator or safety and health coordinators, does not relieve the client or project supervisor of their responsibilities in this regard. Notwithstanding the responsibilities of safety and health coordinators, the main responsibility is the owner, the client. The responsibility of the client and the project supervisor is predominant and cannot be delegated to third parties. In section 8 and throughout the draft legal act proposed by SLS, there is no provision that emphasizes the responsibility of employers. Indeed, the responsibilities of the client, project supervisor, and the general contractor shall not affect the principle of employers' responsibilities and should not affect this responsibility, as provided for in the Directive 391, the Framework Directive, in particular, to assess the risks to the safety and health of workers and to implement the necessary preventive and protective measures. It is vital to stress the non-delegable responsibility that each employer has to ensure the safety and health working conditions of their own workers in every aspect related to the work. Slide 11, please. In paragraph 1 of section 9 of the draft legal act proposed by SLS is mentioned that natural persons must, in quote, take care of their own safety and health and that of other persons like to be affected by the workers' acts or omissions at work in accordance with their training and with the demands of clients or project supervisor and coordinators for labor protection matters, end of quotes. Well, first of all, do not forget that for the purposes of the labor legislation, a natural person is not the same as a worker. And the wording of the provision as it is, containing the word worker, leads to bewilderment. So the spirit of the Framework Directive 391 and all the resulting social directives is to focus responsibilities on the employer and on the entire subcontracting chain, which starts with the owner, the client, or the project supervisor. Naturally, workers also have obligations, see in Article 15 of the directive. Conversely, it is contrary to the spirit of the Framework Directive 391 to assume from the outset that the worker has had flaws and omissions in the field of safety and health at work. On the contrary, there must exist a planning of safety and health at work, duly integrated into each technical gesture, accompanied by the necessary training and information for workers. For a liability to be attributed to a worker, an omission or a harmful act, it will be necessary that nothing has failed in the entire chain of responsibilities, which starts with the owner, the client, goes to the general contractor, going to the other contractors, employers, not forgetting the safety and health coordinators. Furthermore, this can only be ascertained in the workplace accident investigation. It will inquire. So the wording was changed to, in quotes, take care of their own safety and health and that of other persons likely to be affected due to acts and omissions resulting from inadequate working conditions at work in accordance with their training and with the demands of clients or project supervisor and coordinators for safety and health. End of quotes. In section 14, the draft legal act proposed by SLES mentions that, open quotes, in quotes, falls from a height of more than 1.3 meters must be prevented with the help of solid cradles, making workers falls impossible, with a height of at least 1.1 meters to the bottom of the top element, which have a top and medium parts and a handboard or an equivalent alternative. End of quotes. Not talking about the wording, which is a little confusing, what stands out for me here is the placement of specific measurements, the specification of two technical elements. Why those heights of 1.3 and 1.1 meters? Does having an handrail at least 1.1 meter height mean it can still be taller than that height? Is it appropriate in terms of work safety to have a main handrail with a higher height? It does not seem like it is, on the contrary. In addition, in particular dimensions are to be set, why not specify also the width of the handboard from the work platform? Are all these measurements in any technical regulation of safety rules in civil construction in Ukraine? Are they common to the standard dimensions of collective protections for scaffolding for sale in commercial establishment and supposedly duly homologated? It should be stressed that collective protections must all have the same dimensions. For example, in the European Union, scaffolds have specific harmonized European technical standards for scaffolding, which, although they do not have the force of law, and therefore are not mandatory, they establish technical specifications that are considered adequate or sufficient to ensure compliance with the technical requirements established in the European legislation. It was therefore appropriate to adopt these same dimensions. Despite everything I already said, the measurements were not removed from the text of the SLS document, as it not know whether they have any connection with the technical legislation in Ukraine, but with reservation regarding what has just been exposed. Furthermore, in terms of legislative systematic, the enactment of the technical dimensions of the collective protection devices to be implemented ought to be included in a specific technical regulation of safety and health in civil construction and not in this diploma. In section 14, paragraph 7, it was necessary to change the title of the provision, in quotes, means of transport, excavating machinery and transporters, end of quotes, to, in quotes, excavating and materials handling vehicles and machinery, end of quotes. The meaning of the title proposed in the document of SLS for this provision modifies what is contained in the directive. In fact, the terminologies, means of transport and transporters leads directly to the transport of passengers, bus, train, airplanes, ship, cars, etc., or the transport of large loads. On the other hand, the meaning of material handling can be expressing as the loading, unloading, and movement of goods as within a factory or warehouse, especially by the head of mechanical devices. So it makes a distinct difference to transporters or means of transport. Accordingly, the title in the Annex 4, Part B, Paragraph 8 of the Directive 57, excavating and materials handling vehicles and machinery, will be technically more correct. Subsequently, the words transporters and means of transport have been deleted. In section 14, paragraph 9, it was necessary to highlight in the provision within the earthworks the word excavating, because it is not obvious that the term earthworks encompasses excavation operations. Therefore, it must be stressed that this expression, earthworks, must include excavation works. So, within the earthworks, and given its degree of danger and specificity, it is necessary to emphasize the excavation operation. Therefore, the emphasis on excavation in earthworks as provided for in the Directive 57 on construction sites. In this provision wording, the expression, in quotes, introduced to a minimum, end of quotes, were also added, since it is not enough to only identify the occupational risks. After this identification, these risks must be evaluated and ranked. In the end, then, preventive measures have to be prescribed to eliminate or reduce, when it is not possible to eliminate them, these previously identified risks to a minimum as possible. However, tackling the existing risks is not included in the proposed wording, remaining only the identification of the occupational risks. Again and again, a risk assessment report that does not have the corresponding measures to eliminate or reduce them is a hollow and useless document. Finally, the expression underground communications was replaced by distribution systems due to, one, underground communications are already included in underground cables, and two, the distribution systems were missing, as is the case of water supply, natural gas, and sewage. Slide 12, please. I ended the alleged imperfections in the translation process, and I will continue with the remaining proposed improvements. So, omission of the definition of the state authority that has the legal competence to promote, control, and enforce compliance with its legal provision. In EU member states, the most common is that the enforcement of the area of safety and health at temporary or mobile construction sites directive is the responsibility of the General Authority for Labour Inspection, supported by the definition of criminal or administrative sanctions. It is therefore recommended to provide that the Central Executive Authority that implements the state policy on the state control of compliance with the labour inspection have legal competencies to ensure the promotion, control, and enforcement of the legal provisions of this legal act, ensuring a better alignment of this legal act with Article 9 of the ILO Convention 155, according to which the enforcement of laws and regulations concerning occupational safety and health in the working environment shall be secured by an adequate and appropriate system of inspection. With Article 3 of the ILO Convention number 81 and Article 6 of the ILO Convention 129, which define the main functions of the system of labor inspection. And finally, with Article 4 of the Framework Directive 391, according to which the state shall ensure adequate control and supervision. It should also be ensured that the violation of the provisions of this legal act is properly covered by legal provisions aimed at sanctioning such infringement. It is recommended to provide for adequate and dissuasive penalties for the violation of the provisions of this legal act in order to ensure their compliance and to better align it with applicable international and European labour standards, in particular with Article 9 of the Convention 155 and the Article 18 and Article 24 of the, respectively, the Conventions 81 and 129. It is also recommended to provide for the date of entry into force of this legal act. It's very important, with the indication of the legislation repealed with its entry into force, the adjustment of its annexes where appropriate, and the implementation of the measures necessary to conform the legal framework with its provision in order to ensure its effective application. Well, thank you very much. I'm at your disposal to questions you want to make.
Thank you, Pedro. I just want to stress that you have in your handovers the text of the technical recommendations on this draft law on minimum OSH requirements for the temporary or mobile construction sites. You have it with you. They are also on the project website. Let me also stress, both in English and Ukrainian, by the way. Also, let me stress that this is the first workshop of a series of 4. The other 3, one of which will be today on the afternoon, will be on the minimum safety and health requirements for the workplaces. And then we will have another one on the 28th, so Wednesday, right? On the morning from 10 to 1 on work equipment with Peter Kaffley. And on the 29th, on the morning also from 10 to 13, we will address the draft legal act proposed by SLS on the minimum safety and health requirements for the use of personal protective equipment. So for now, I would propose to have a break until 11:30, so half an hour break, to have a coffee, to have some conversation, informal conversations between us. And we will resume work at 11:30 and with specific questions addressed to Pedro Brás. But of course, should you have any additional questions besides the ones that are foreseen on the agenda, so you are kindly invited to either raise your hand on the Zoom or to write down on the chat Petanya, and we will get you the floor so that you can ask your questions. Thank you so much. So see you back in 30 minutes. Thank you, Pedro. Don't go away, Budlaska. Thank you. So we will resume our work. Basically, the SLS who drafted the legal act proposed, we asked them to tell us what they need to know and what clarifications they need regarding the technical recommendations, and they provide us a list of questions that we forward to you. So I will pass the floor to Alexander Ignatov from SLS, which is the director of the labor protection area at the State Labor Service of Ukraine, and he will ask you some questions. Most of them already forwarded to you. Anyway, besides this list of questions, anyone that have other questions can put them also. You can either raise your hand if you are on Zoom, or you can also write on the chat, Petanya, and we will give you the floor as soon as possible. So, Alexander, the floor is yours. So, please address your questions to Pedro. You will be happy to clarify them. Thank you.
Thank you, Antonio. And above all, I would like to express gratitude to you, Pedro, for the professional analysis of our draft. Quite a lot of things that we wanted to clarify have been clarified actually, but we still have some outstanding questions that probably we need more details about. So let me start. We categorize these questions by topics, and first, this is coordinator for safety and health matters at the project preparation stage. And the questions are, what are qualification requirements to the coordinators? Thank you.
Okay, thank you, Antonio. Thank you for the question. That's an important question because in the EU, there are some countries, namely my own country, Portugal, that have made a huge mistake. And this huge mistake is not defining the health and safety coordinators' profiles. Well, since in Portugal, for example, since 25, 30 years, the profiles of health and safety coordinators are intended to be enacted and designed. What is the problem? The problem is when we compare with the other countries that I've already did some that profiles strictly defined, the results are much better. Notwithstanding, I have two. I could say I propose two ways to deal with this question. First of all, it's very important to define the profiles of the health and safety coordinators. It's up to each country to do that because it's not in the text of the directive. The directive doesn't oblige each country to have a specific profile. They say that must be persons with the properly suitable qualifications to fulfill that mission of health and safety coordinators. I would say that could be technicians, civil engineers, architectures with specific training and health and safety, namely, and health and safety and the Directive 57 and then also in the Framework Directive, because in most of the countries, these questions of health and safety are not prescribed in the syllabus of each course in the college, in the university. So it's important to have these technicians, engineers, architects, but which can add another training in health and safety, namely in the Framework Directive and the 57 Directive in construction sites. This is a way, but I would to stress also that it is important in the activity of the health and safety coordinator to see the fruit of the trees. We know that we have a good tree when that tree gives us fantastic fruits with savor, sweet fruits. We know we have a bad tree when that some tree that doesn't give us the fruits that we wanted. That's the same to the workplace in terms of health and safety. It's the same mutatis mutandis with a mobile construction site. It's our duty when we arrive to a construction site and to assess the activity of a health and safety coordinator to see, first of all, the fruit of the tree, all the aspects of health and safety in the construction site. After that, of course, it's my opinion, it's very important to have the profiles of the health and safety coordinators at project stage on the field, precisely defined and acted clearly to everybody understand what is in case, which is important to deal with in the field. So I think could be architects, civil engineers, technicians with medium courses, but with deeply course training and health and safety, and then the Framework Directive, and then the 57 Directive, because without that, it's not enough to be architecture or engineer to have to be a health and safety coordinator. I'm sorry if I don't know if I answered to your question properly.
Thank you. Yes, I hear your answer. And I understand that both us and you still need to undertake a lot of steps to achieve that. But okay, we'll be doing that. So then how are they appointed, the coordinators? I mean, if we need to have some labor contract, civil contract with them, do we appoint them to a certain position, again, based on Portuguese best practices?
To Recibo Verde in Portugal or a service contract?
Okay. Thank you for the question. Well, I could say you a very problematic answer. It's my personal opinion, of course. It depends. It depends of the size of the construction site. It depends of the relations of the dimension of the owner, the client. For instance, if you have a little construction site, a house, a small building, in which it won't necessary to a health and safety coordinator to still in the construction site 8 hours a day. I think it's not necessary to have a formal labor contract, because this health and safety coordinator could also have another civil construction sites to deal with. It's not a problem for me. But if you have a medium or great, huge construction site with bridges, huge buildings, private buildings, with special works, with more than, for instance, 50 workers, perhaps it's for sure that you have to have a health and safety coordinator permanently in the construction site. In this case, the owner should have a labor contract to this health and safety coordinator. You know, this depends of the degree of autonomy of each coordinator have to deal to fulfill this job on the field. But you have another example that could happen also. It's you hire not a person, but an enterprise specialized in health and safety coordination. If you have a huge public work or a huge private work, buildings, I don't know, with 100 works or a very huge dimension construction site, perhaps it's not enough to have only one person, only one coordinator, health and safety coordinator to deal with this problem. You have to hire a specific enterprise in health and safety coordination with several coordinators. In this case, it will be a civil contract between the owner, the client, and this enterprise. And of course, this enterprise must have labor contracts with their employees, their coordinators in the field. So I think it depends. It depends of each construction site. You know, the health and safety coordinator, to deal with some degree of autonomy, have to have some degree of specialization. And you have to see if you have a construction site with a permanent health and safety coordinator or no. It depends, in my opinion. But it's my opinion that the directive doesn't say nothing about that. One thing I can say, if I find in the workplace an enterprise, an health and safety enterprise that have employees, other health and safety coordinators, I oblige them to have labor contracts, of course.
Thank you for this response. Let me continue. Under our legislation, the contractor can be a private person. This is any person which has enough financial resources and is willing to construct something. So in your opinion, what would be your recommendation? Maybe according to your practice, what's the way to regulate the relations between the coordinator and this private person through contract, through agreement, or through some other means? Thank you.
If I understood, the private contractor, it depends of the owner also. It's or is also a client.
Yes. What if a client is a private person?
It's employer in the field. If I understood. It's a person that depends of the owner, the client, because I didn't understand correctly. This private person, it's an employer also, or it's a owner, a client.
Ignatov, we don't understand the question. Can you repeat the question, please?
So when the private person wants a construction, this is not an employer, this is a private person.
Okay.
But under the law, he should appoint a coordinator.
Okay.
Your own.
Okay, I understand. Okay.
So the criteria to nominate is the same. The number of it's for you to respond.
No, Antonio's already said it's the same. The rule has to apply also to the private person. And you have to hire also a health and safety coordinator, unless that he himself could be a health and safety coordinator with the suitable qualifications.
Thank you. So let's continue. And now let's proceed to the safety plan. Here we've got more questions. Maybe we do not have enough practice. We have similar documents. However, we would like to ask you about this plan in the spirit of the directive. So what are the requirements for people who compile these plans? So who should develop these safety plans and what qualifications should they possess? Thank you.
Well, I focus the answer in the client and in the health and safety coordinator. Notwithstanding of the health and safety coordinator could hire another person to draw up the plan, the responsibility, the technical responsibility is up to the health and safety coordinator, and the main responsibility to approve this plan is the client. So I don't care who drew up the plan. I care with who approved technical the plan, the health and safety coordinator, and who approved finally the plan, the client. Who drew up the plan? I don't care.
It's the result that counts.
I'm focused in the rigor, in the technical assertiveness of the document. In this technical assertivity of the plan, it's up to the health and safety coordinator, and who approved this plan is the owner. In this, the two persons, health and safety coordinator and the client, are the main responsibles of the technical plan.
Thank you. I've got one more question. We've got Article 5, Part B in the directive. It's about the safety plan. Is this an exhaustive list? that should be a checklist for an inspector when he or she visits the construction site, or this is a non-exhaustive list. The plan can be improved, it can be expanded beyond the scope of Article 5.
The plan should be expanded beyond Article 5, it's my opinion, because directive gives us guidelines, clues to follow, and the experience in the field, my experience in the field says to me that the plan should go beyond beyond the directive. For instance, our Portuguese legislation and the Spanish legislation, the French legislation, all of them go beyond the content of the directive. Because the experience says to us that, for instance, it's important to have the written record of the health and safety coordinators, for instance. It's very important. It's one of the examples that could be very important to have in the plan. The detailed work schedule, the name of identification of the employers and all the chain of responsibilities of the employers in the construction site. The emergence procedures, for example, that including rescue and evacuation measures. I don't know, project parts with relevance for the prevention of professional risks. Registration of the activities inherent to the prevention and professional risks. Who knows the professional risk assessment audits that someone external could do in the construction site, which means that with the experience in the field, we should have to have more technical aspects to improve the document, because the health and safety plan is the cornerstone of all the prevention dimension of the construction site. It's a plan, a dynamic plan that should be changed during all the construction process, because in every days, every weeks, we face it with another specific works that are not detailed in the plan. It's not a problem. We have to stop the works, assess the new works that we have to deal with, make a risk assessment, and prescribe new measures to work safety and to preserve the life and health of the workers in the construction site. So I think they are guidelines, they are not exhaustive, and our experience advises us to have more technical questions in order to guarantee health and safety construction site. Of course, this in dialogue with the social partners. It's important to construct and to build up everything with the help and the work of the social partners with us, because it gives us and give to them also the responsibility to have a good environment, health and safety in the workplace.
And I would like to add that we are talking about minimum safety and health requirements. They are minimum. It means that at least those should be on the law. They are minimum. But usually the countries in the EU, and Portugal included, they set other requirements besides the ones that are on the directive. But the ones that are on the directive are mandatory. But you can add more if it makes sense. And in this particular case, it looks like it makes sense.
Let me, if I can say more one detailed thing. For instance, I said registration of activities inherent to the prevention of professional risks, but more detailed things like control sheets for equipment and installations, models for assessment reports of safety conditions in the workplaces, work accident inquiry sheets, and notification of subcontractors and self-employed persons. For example, things that could have prescribed in the health and safety plan.
Thank you for this response. And I have another question. Let's say a labor inspector visits a construction site. Somehow the inspector should check the safety plans. Can the inspector decide whether the measures are sufficient, or the inspector would need some assistance from experts? So can the inspector, under his own responsibility, say that this plan is sufficient or insufficient?
Well, this is, I thank you for the question, because it's one of my best preferred questions to answer because it implies directly the activity of the labor inspector in the field, not only in construction sites, in all workplaces, to assess if a health and safety plan is suitable or a risk assessment is suitable in a factory or in a library, for instance. My opinion, it's the labor inspector have to say if the document is suitable or not in terms of health and safety for some workplaces. Because if a work inspector doesn't say anything, it's useless their work in the workplace. It's useless. So I can have and I can ask also the help of an expert if necessary, of course. But the final decision is up to the labor inspector. So you have to be training, you have to have knowledge, you have to have experience, but the labor inspector should have the ability to say if a work and safety plan is suitable to that some workplace. Well, of course, if we talk about huge construct sites, which specific risks and bridges, very technical questions, he should have the right and the right to help to could talk to any inside the work inspection, the labor inspection, or outside the labor inspection, to someone could advise him about technical questions very specific. But in general terms, the labor inspector have to have the duty to say something about the document. For instance, if I have a tower crane in the health and safety plan, and I face a small house without any tower crane, I have to say to the owner, to the client, to the general contractor, well, this document it's not suitable to this construction site because you don't have any tower crane here. For instance, if I have explosives to use to dig great walls in the ground, and I have a small house, I have to say that this health and safety plan, it's a copy from another plan. It's not suitable to this construction site. In general terms, to very small specific questions, of course, the labor inspector should have the possibility to demand someone to help them to deal with in the field, of course. But the final word, the final decision should have to the labor inspector.
Maybe I can add something. Usually, for example, in Portugal, labor inspectors have trainings on risk assessment, how to assess risks, what should be the measures that should be implemented in several different situations of risks in any industry. And a labor inspector, when he comes to a company and he is dealing with an inspection visit on OSH, he should really ask for the assessment of the risks, and he should analyze it. And he should be prepared to analyze it and to check if the measures proposed make sense. And if it doesn't make sense, he has to determine to the employer to properly assess the risks, and that's it. In Portugal, they have this power, and in Spain also, and in other countries in Europe. And as for the safety and health plan, it happened to me several times that I go to make an inspection visit to a construction site. I check the health and safety plan, and sometimes it has the address of the construction site, which is not that one. The guys are using the same safety and health plan that they use in another construction site. You know? So, and of course, the labor inspectors in these situations, what they should do to put a fine on the employer because he's trying to fool you, because he's misusing a safety and health plan that was made for another situation on that situation, and also notify him to really assess the risk and to draft properly a safety and health plan. But again, labor inspectors are not expected to assess risks or to make safety and health plans, but they have to be able to analyze them and to determine if they are well done or not. And in case they are not well done, determined to the employer that he has to do it properly. But it's not for the labor inspector to do it himself. He can suggest how to do it. He can check if it is well done or not, or he can demand that it is done properly. Thank you.
Thank you for this explanation. Thank you both, Pedro and Antonio. We've got another important aspect, such as self-employed people working at construction sites. So what would coordination be for them, for these self-employed people? Is it possible that these self-employed people are involved in high-risk activities at construction sites? Are there any restrictions for these people?
Thank you. Yes, as long as they are true self-employed persons, first of all. Second, as long as they are included in the risk assessment of the health and safety plan, and they have to comply with the rules that are already prescribed in the plan and by the health and safety coordinator, and of course have the proper training and suitable training to deal with this kind of workers. And works, I'm sorry. It depends of the degree of technicality that they should have to deal with some aspects of the work, because there are some technical works that must be assessed by the specific technicians also, which means there are some tasks that only some specific persons know how to deal with. But the main rule is to have, amidst the health and safety plan, you have to comply with all the rules on the construction site, and all the rules that are determined by the employer or the client that have hired that self-employed person. But most of all, should be a genuine, a truly self-employed person.
May I add something? I think in at least in Portugal, that I know better, there is no to my mind, there are only restrictions to two different types of workers on the performance of high-risk works, or three situations. One is if it is a minor. And minors cannot perform certain types of works. Then other restrictions are for temporary workers.
Yeah.
You don't have it in Ukraine, but temporary work is like a triangular relation in which a worker is employee of a temporary work company, which has a customer. So it's like the temporary work company rents the employee to a user company. And in this case, this worker cannot perform high-risk workers and cannot be worked in civil construction, but it happens in Portugal. But if it is to comply with that, they could not. And these are the exceptions as I can see them.
Yep.
It doesn't have to do with being a self-employed, because in Portugal we also have the misuse of self-employed. It's like misuse of civil contracts. In order not to pay social security, they hire employees as if they are self-employed. We have that problem in Portugal also. But for this kind of legislation, self-employed are seen as a regular employer, not as an employee, if they are really self-employed. If they are bogus self-employed, they are seen as employees. But if they are really providing a service, they are treated on this law as employers. And they might have employees of their own. So for this law, for the OSH law, etc., they are always seen as employers, with the exception of if they are economically dependent on the employer, you see, on the customer. Imagine that I'm a self-employed, I don't have employees, and 80% of my income comes from one company only. So I'm considered like I'm a self-employed because I don't have a schedule. I don't work with the work equipment of the beneficiary of my activity. I don't work on their permits, etc. So I'm really a service provider, but I don't have employees. I just work for that guy, for example. So I'm economically dependent to him. So in that case, I might be understood by the legislation as being an employee just for OSH purposes. You see what I mean? That was what I would like to add. Thank you.
Thank you, Antonio. And I believe on my own behalf, my last question, maybe I will add more later, but here it is a very important and interesting aspect. This is providing information to employees and their representatives at the construction site. How that happens, if it is somehow registered, who does that? Because we know that at the construction site, there may be self-employed people and several organizations may be working there. So what's the role of the coordinator and whose responsibility is that information?
So it's the role of the coordinator. Let me talk. Let me say something after that I want to say. The health and safety coordinator is the harms and the highs of the owner, the client in the construction site. It's like a robot. Should be. So he has the power to determine to the employers what the rules must be complied. He has the power to take the health and safety plan and give the health and safety plan to the general contractors and the employers and oblige them to comply with. So he have to have proofs also to make responsible these employers and these contractors in the field. How? Made records of the training sessions, of the training rules, of the meetings, the week meetings, the monthly meetings that the health and safety coordinator do with the general contractor and the employers in the construction site. And this is very important, to have a record of each meeting, a record of each instruction, and before that, have a plan, a structured plan to how communicate my decisions, how I could communicate the rules of the health and safety plan to the employers. I could deal with several ways by doing meetings every day, depending on the size of the construction site, doing meetings weekly, monthly, I don't know. But for each meeting, it should be necessary, it must be necessary to the health and safety coordinator have a record. And this record, it's important also to the employers have also this record, also signing for all the parties, doing minutes, duly signed, and according to all the parts have the responsibility to comply with the rules that are in the health and safety plan in each construction site. I want to point it out. In the end, it's up to the client, to the owner, to have the power to fire the employers that don't comply with the rules in each construction site. Because he's the owner. In my house, I invite persons to dinner with me, to eat with me, but the person has to comply with my rules in my house. It's the same in the construction site. So it depends of the proficiency of each health and safety coordinator to have this record duly registered and duly structured. The same to the employers, because all of this, the main responsibility of the strategic compliance of the health and safety coordinator in the construction site, it's one thing. Another thing, it's the responsibility of the employers for his own workers. because employers with these own workers have also this responsibility. How an employer could give the rules to their own workers? How is, if a labor inspector asked to a worker if did some worker have or no, has or no the duly training of health and safety matters with documents. With documents. If I have a little session in the morning to training a set of workers because they will be in the afternoon a very specified danger work, I have to have a training session with 15, 30 minutes. And this session, in these sessions, I will explain difficult questions and the matters that are in the health and safety plan. In my opinion, the employer or the health and safety coordinator have to draw up a sheet with the aspects that are spoken in the meeting and oblige the workers and the employers to sign this sheet with the health and safety coordinator. It's a non-stop process. It's not easy, but it's a non-stop process. It should be done. It's not easy. Namely, in the construction site, as you said, with the permanent changing of workers, employers, kinds of works, sometimes big confusion, but it's a question of discipline because we know from our experience this discipline reduces the work accidents and the health diseases. And this is a proof. It's like a technical experience. It's a technical experience. We know that the construction side, with these rules, with these commands of health and safety coordinators and the plan and the client, have a completely different result in terms of working safety accidents.
Thank you, Pedro. Alexander, any more questions?
Thank you so much, Pedro. And now maybe I will pass the floor to my colleagues to also come up with questions, and I believe they do have questions. So far, thank you on my part, and if I do have more questions, I'll join them. Thank you.
From the part of SLS, from the part of the ESOS, any questions? So you have the floor.
Так, чутно мене.
Can you
present yourself because Pedro doesn't know you. Thank you.
Мене звуть Ольга Богданова.
Olga Bogdanova. I represent the Union of OSH experts, and I'm very grateful to Mr. Brash for very detailed analysis of the document. And these recommendations that you come up with, they're very valuable. And I am especially grateful for your highlighting this difference between hazards and risks, which we actually need to reflect in all of our documents. And in the draft document that we have received, let me mention that high risk or high hazard work, this is a term that doesn't exist internationally. So you cannot be like half merit. If we adopt directives, we need to use the respective terminology. Absolutely. So my recommendation to this draft law is that we use correct terms: hazards, risks, and higher hazard or lower hazard work. It is not a term that would be used in Europe. So thank you again for highlighting that. Now my question. Since 2018, or 17 actually, we have been having the regulation on OSH that is based on this directive. And it works. I mean, there are some aspects to that, but it is functional. So I have this question. One goes to Pedro, another one goes to Alexander. First, based on your extensive experience, Mr. Pedro, so if you take Portuguese construction sites, all of them as 100%, what is the proportion that more or less comply with requirements of the directive or minimum requirements? And a similar question I will address to Alexander. because for 3 years now, we've been having these regulations enforced in Ukraine. So I will not ask you about the percentage of our construction sites that are compliant with the legislation. We know the answer, actually, but let me ask the question differently. What prevented and what still prevents you from implementing even these regulations that we already have approved? So, starting with coordinator issue, you're absolutely right that it is an issue. However, well, sorry for taking so much of your time, but maybe you could address these two questions now, colleagues.
Sash, Alexander, you have the floor, and then I will give it to Pedro.
Thank you. Since 2017, when the Act was adopted, SLS has implemented several awareness-raising campaigns. Provisions of this document were to some extent new, but we also, I would say, we have had that experience. Well, there were different names to those processes, however. So SLS had the clear understanding that it won't be clear to the industry who the coordinators are, where they come from. And even early this year, if I'm not mistaken, we had another awareness-raising campaign on construction sites. Our inspectors, I won't tell you the exact figure, how many of them and how many sites have visited, but that was a wide-scale campaign. We visited a lot of sites. In 2018, they would look at us as if we were like talking nonsense. But now there is certain understanding that we understand that our construction sites are far from perfect. And coordinators at our construction sites are not present everywhere, not always present. And even notification of the start of construction that you need to send to the territorial body, a responsible body, well, that was not seen as something necessary. That was seen as additional burden on businesses, etc. But now, actually, all construction sites have got used to notifying of start of the work. So I wouldn't say that this regulation has been implemented perfectly. Even the document that we have, it is really hybrid, half Ukrainian, half European, half Soviet. However, even what we have, there we try to promote it actively so that it were implemented in construction sites. Now, I believe we have this quite good institution to train coordinators. Well, some may disagree, but we have more or less kind of training or curriculum for coordinators. This is not just presenting the document, but that's about professional approach. Who can become a coordinator? Ballet teacher cannot become coordinator at construction sites. So they undergo certification. Olena Leonidovna can add more to that. But it's better to have something, at least something, than having nothing. Because initially there was an attempt to replace training of coordinators with the simple introductory OSH training. However, the curriculum that we have now, well, it is not perfect. I don't know all the details of how it has been implemented, but based on the information that I do have, it seems that this is done professionally enough now. Thank you.
I suggest that you might even address the awareness-raising campaigns promoted by EDICT. Thank you.
Well, I will give you an empirical answer or a round answer because I don't have statistical figures to answer, to respond to that question. But I will answer differently. Well, if you have a spacecraft, airplane, and you landed in Portugal in 1998, and you landed today in Portugal, you could see, in terms of construction sites, different planets. not different countries, different planets. So since 1998, I could say that we have made fantastic work in terms of developing health and safety in construction sites, not in every workplaces, construction sites. So, but with this answer, it's not the same that saying to you that we have a fantastic work construction sites in terms of health and safety. No, we don't have. We are far enough where we are, notwithstanding that my opinion, we are far away of have a good environment in terms of health and safety construction sites in Portugal. However, we have in this moment two realities in Portugal. One, in terms of medium and great and huge construction sites, I would say that we have good construction sites in terms of health and safety. Good, not sufficient, but we have good in terms of health and safety, medium, huge construction sites. We have good and very good health and safety environment in these workplaces. And we have a problem with the small construction sites. In terms of small construction sites, we have colossal, huge problems with in terms of little and small construction sites. So we have two realities. The first reality, medium and huge construction sites, that results from our work. And our work, it's not the work of the Portuguese Labour Inspection, no. The work of social partners, different governments, and of course, Portuguese inspection. We are in the middle, of course. We have made the national campaign in 1996, 1998, in terms of civil construction, that was simultaneously with the huge construction sites we have in this year, 1996, because we have the universal exposition in Lisbon in 1996. It was a laboratory in terms of tackling health and safety shortcomings in our construction sites. The exposition 1996 was a huge laboratory for us, and our campaign was done simultaneously with this exposition, with the works. So today we have two realities: medium in huge construction sites. I could say we have good, not excellent, but good, very good environment in terms of health and safety, and small construction sites. We have, I don't have an adjective to describe some realities that I face with. So problems with the small construction sites.
Thank you so much. I commend you on this progress. I wish all of us to speed up. We do not have this time to lose. We cannot waste time. We cannot waste people's lives. Can I ask another question? You have mentioned correctly the works that are executed at the height of 1.3 meters. The directive does not indicate the height. Everyone realizes that 1.25 is dangerous as 1.3 meters. So why do we have in our rules this parameter 1.3? And what would be your recommendation to proceed with this recommendation? Should we keep some particular parameter, or should we follow the British example? They indicate such works as existence of elevation or deviation in the height.
So, Pedro, you might start. You understood the question?
Yes, technical dimensions.
Why setting 1.3 meters and not 1.5, 2 meters, whatever?
Yeah. Well, this first of all, I think it's not the suitable document to prescribe these measures. I don't think it could be this document. It's my opinion, because it's a strategic document, not a technical. It's a technical, but it's a strategic document. You have to, in my opinion, also to draw up a technical document in terms of specificities, technicalities in the construction sites, a regulation and construction sites, for instance. In relating to the 1.3, 1.1, 0.9, 0.9, it's in Portugal we have 0.9, and we have 0.45 in the handrail, intermediate handrail, and we have the end board also in the dimension I don't remember, but 0.05, 0.06, I don't remember. But I think it's important before to prescribe that measures, to see what you want to do with that measures. Or if you want to buy scaffolding in the European Union, you have to adapt the measures to the dimensions of the scaffolding, because the scaffolding are devices that are already homologated by the EU, by the private organizations that are recognized by the EU. And the scaffolding are the same dimensions in all the EU. So in Ukraine, you have to assess and analyze what you want to do with your devices, with your PPEs, with your in other questions also. So I could say that what is prescribed in the homologated scaffolding, 0.9, but I don't know what you want to do with these questions, because if you buy some, because imagine that you prescribe 1.3 and you buy scaffolding one with 0.9. Well, what is, it's a problem to the labor inspector when he arrives to a construction site. What is the measures that are mandatory? So I think, first of all, I think we have to think what kind of dimensions and what kind of systematic structure in terms of diplomas you want to adopt.
Ignatov, do you want to add something?
Yes, I would add a couple of words. We realize that our regulatory acts are not ideal, not perfect, but they are not that bad, of course. We should draw up, as you have mentioned, technical documents, but first of all, we would need a new law that would regulate these issues very stringently. At the moment, we cannot implement the directive because it does not fit into our legislation. So first, we should finalize our national legislation in this respect. And then we will also review our bylaws. So this 1.3 meters, that's historical tradition, let's say. Maybe we should update these standards, because we realize that our bylaws the number of our bylaws should be reduced as soon as the law is adopted, and hopefully new bylaws will be of better quality.
I just want to make a comment on the question, on your first question, Olga, about the percentage of compliant construction sites in Ukraine and in Portugal. Just to say that, I would say that in Ukraine there are two things that put at risk the compliance rates, and that is, for example, one, the fact that the law that you mentioned, it's not that legal act, it's not a law. It's not even a CMU decree. It's a Minister of Social Policy order. And of course, it means that it does not have the legal power to put aside contradictory legal dispositions that are still in place and valid. That is a problem of compliance, because the employers, even if they want to comply, they don't understand. The labor inspectors, they want to enforce it, but they don't understand, because there are a lot of different laws saying different things. And if one has a higher legal power, so it would put aside the other ones, but that is not the case. It is a minister order also. So it has this problem. And then it does not connect with the law on labor protection, because the concepts are a bit different. So it's a confusion. That's why it would make sense. First, adopt the OSH draft law that is being discussed, and then the individual directives in a way that they talk all to each other and do with the OSH draft law. And also, one aspect that Pedro already mentioned is that the legal act that would transpose this directive on minimum OSH requirements for temporary or mobile construction sites should be a CMU decree, precisely to avoid the difficulties in implementing a minister order. And across Europe, the individual directives are implemented by CMU decrees all around the Europe. And the OSH draft law usually is a law, because otherwise it is very difficult to put in place the system. You have beautiful laws, but no one will comply with them. So, and the other reason is labor inspection lack of powers, because in Portugal, a labor inspector is going home and this is a construction site with some problem, he can intervene immediately. In Ukraine, you have to contact the employer, notify that you are going there. Of course, he goes there, everything is okay. So he has to ask permission to go. Then he has to make inspection visit during the regular hours. Even if they work on the weekends or if they work at night, labor inspector cannot go there because it's not the working time. Third, labor inspectors cannot go there and make an inspection visit if the owner is not there or his representative. So if I was the owner of a construction site, I will not set my foot on the construction site. And that's it. There will be never any inspection visits. And finally, with the moratoriums, also doesn't help, because even if they have the powers, if there was a moratorium, they could not act. And by the way, I don't know if you are aware of that, but since the beginning of this month, no, since 14th of September, labor inspectors in Ukraine cannot do inspection visits because there was this sixth court, appeal court, administrative sixth appeal administrative court that repealed the CMU decree 823. So since then, since 14th September, Ukraine doesn't have labor inspection visits. What I mean is that there are a lot of reasons why you can find these situations here. So let's move on. I would give the floor to Tatiana Gorum that requested to make a question. So Tatiana, you have the floor.
Good afternoon, dear participants. I represent the Federation of Trade Unions of Ukraine. Can you hear me well? So, good afternoon. I represent the Federation of the Trade Unions of Ukraine. I'm the deputy head of the technical surveillance of labor at the trade unions. I agree with Olga. The new act issued in 2018 was indeed the order of the Ministry of Social Policy. Now these powers are with the Ministry of Economy, by the way. So the question is about the application. It doesn't matter whether it's the decree of the ministry or the order of the ministry. Anyway, this should be an act that makes the policy. There is a problem of application. I understand. The problem of enforcement is what matters now. I agree with Antonio that there are also problems with the employer's responsibility, because the responsibility is very low, much lower than for the violation of labor legislation, and limited powers of inspectors. These three problems should be fixed. It doesn't matter whether it's a decree or an order of the ministry. The status of the document will have no impact on the enforcement or improved situation with the safety. So these legal acts, again, are binding for all entities. I believe it is expedient to make amendments to the decree, to this order. And if this order is supposed to become a decree, I'd like to remind you that according to the rules and procedures of the Cabinet of Ministers, the order is not a legal and regulatory act. So it is not possible the order of the Cabinet of Ministers cannot revoke other acts. Just the decree of the Cabinet of Ministers has such power. And I was really surprised as I was listening to you. If you remove some words from the title and from the body of the text, namely the workers, you remove the word workers, you are speaking solely about the workplaces, but the safety and health, this pertains to workers, not to workplaces. This is the first point. And then in the text, the workplaces word is used. The convention and the directives use the word workplace, and it's a broader term, broader concept, encompassing all territories, all areas adjacent to the workplace. So maybe we should use two terms at the same time, workplaces and workstations. Then another point about the general provisions, namely safety and health plan. Whose safety and whose health? Here we should write workers, should we? It is not a new thing to draw up such a plan. You know that according to our legislation, any company, any enterprise, any construction site should be equipped with a comprehensive action plan to increase the level of safety. This safety plan should be in place everywhere, and it should be applied in the same way. It doesn't matter what title this document has. So let me also remind you that this plan, according to our current legislation, should be developed by the employer in a mandatory manner, according to the provisions in the collective agreement. Then, paragraph 3 in the 11th section. The translation doesn't matter here. The application is what matters. So the employees should have the right to ask or to approach, as the initial version says. It's the obligation of the employer to care about the safety and health. Therefore, the representatives of employees, representatives of workers, have the right to request, to demand, because ask is a too soft word. So they have the right to demand. Then paragraph 2 of section 13, minimum requirements to workplaces. You propose to replace substance and dust by words deposit and dirt. We should be very cautious with such replacements in our legislation, because there are other bylaws and standards and hygienic classifications. They also have mention of the various concentration thresholds of dust and substances. So it is important for this document to correlate with other legislative acts, such as hygienic classification. We cannot just replace these words with deposit and dirt. Such terms do not exist in the hygienic classification. And if there is a discrepancy of terms, we cannot speak about the calculations of the admissible concentrations. Then, regarding the safety plan content, where you're speaking about the awareness raising and the training requirement, this specialized directive implies that not only the workers should be trained and informed, but also their representatives. So according to the framework directive, the employer has an obligation to inform and train workers and their representatives.
Thank you for your clarification. Thank you, Pedro. Thank you, Antonia. Thanks for your recommendations.
Let me make 2 or 3 comments before I give you the floor. Tatiana, thank you for your comments. I just start by the last one, that you say that according to the the directive, the framework directive, not only the workers should be informed, but also the representatives of workers and trained also, right? So that's why it is proposed on this one of the recommendations of Pedro to this draft legal act is to say that the provisions of the national legislation that transpose the EU OSH Framework Directive 89391 are applicable here without prejudice to more stringent or specific provisions. So it means that the provision of the national legislation that transposes the directive that says that employees and their representatives should be informed and trained is valid here. You don't have to repeat it. Because when you say that the provisions of the national legal act that transposes the directive are directly applicable, it means information, training, consultation, everything that is foreseen on the general OSH law applies here at the construction sites, including the information and training of the representatives of the workers. So you should not repeat everything that is there on this one, because you would have to repeat the same in each and every individual directive. So no need. You just have to put an article saying that those general provisions are directly applicable. Another question is that you are a bit mistaken and you are not providing a very good service to the workers that you represent, because you don't understand the issue here. And the issue here, when you say minimum requirements of the workers, it's not the minimum requirements of the workers. The workers are not required to. They are entitled to receive. But if you put minimum safety and health requirements of the workers at the workplaces, you are putting the responsibility of verifying the requirements to the workers. So you are doing exactly the contrary that you want. You understand what I mean? It's not requirements of the workers. No, it's requirements of the workplaces. It's requirements of the construction sites. It's requirements of the PPEs, not of the workers. So that's why we took workers from the title, because that makes sense. It's requirements of the mobile and temporary construction sites. It's not a requirement of the workers. You understand what I mean? And because otherwise you are putting an onus on the workers. No, you should not do that. Everybody understand that the ultimate beneficiaries of this legislation are the workers. But you should not say minimum safety and health requirements of the workers. Those doesn't make sense. And besides, this legislation imposes obligations not just to the employers, also to the coordinators, to the contractors, to the employee, to everybody, to the client, to everybody. And why? To provide good safety and health conditions to the workers, but not just to the workers. The persons that have to visit the construction site, the persons that might be affected by the works that are being developed on the construction site. And also for the employers, because the employers, imagine I'm a self-employed and I have 3 workers working for me. It's not just for my workers. It's not just my workers that need to have good working conditions. I myself, as self-employed, I also need to enjoy good working conditions. And if I'm a coordinator for either for the project or for the execution phase, I also want to enjoy good working conditions on the construction site where I work. Why shouldn't I? And the fiscals and the inspectors from the city hall and the labor inspectors that go to the site, they should be also enjoy good working conditions there. So that's why we should not talk about minimum requirements of the workers. No, it's not the workers. It's about the workplaces, the construction sites, the use of PPEs, the use of work equipment, etc. It's requirements of the activity or of the workplace It's not requirements of the workers. Other aspect is that you don't expect that the EU will alter all the directives to adapt to the Ukrainian terminology. I'm sorry. EU will not change its terminology to adapt to Ukraine. You understand? So Ukraine should adapt its terminology to the EU, not the other way around, because otherwise you will not align anything. You see what I mean? So, and if you have to align this national legislation with this directive, and you have a lot of bylaws and other legislation that use a different terminology of this one, so those have to be altered too. Those have to be altered. And I'm very sorry to hear that the joint representative body of trade unions and employees organizations are stick to this logic that you are showing, which is that you propose that the OSH draft law should be based not on the EU directive on OSH, but on your legislation on labor protection, and that the terminology of labor protection, probably hygiene also, should be maintained. Well, I don't know who do you want to align to, because you will not find it in EU. You won't. Another question, and just to finish, no, that's pretty much it. So I will give the floor straight away to Pedro, not to make us lose more time. And Pedro, if you could address the remaining comments from Tatiana Goru, I would appreciate. Thank you so much.
Okay, thank you. I think you already answered to everything. I don't know.
No, I would ask you just I was about to do it, but no point, is to explain what is the difference between a workplace and a workstation, because, and the problem is not that they don't want what is one thing and the other. The problem is that Ukrainian language doesn't have a translation of you see, because everybody understands that a workstation is a precise place, spot in a huge workplace in which, in principle, only a worker should be assigned to. Whereas workplaces is a area, and I'm sorry, I see you are moving your head. No. Why is he?
I have a small question there. In Portugal,
she doesn't agree with me, but the idea is this: imagine a factory. A huge factory is a workplace, and on a workplace you have imagine you have a work equipment, and in the work equipment you have a huge work equipment with several stages of production. In each stage you have a worker. He has his place in front of a machine. So for the EU, workplace would be the factory, the entire factory, and workstation is the place where each worker sits in front of the machine. For example, Tatiana, you work on a trade union on that beautiful building in Maidan Nezalezhnosti, right? So I would say that is a workplace. But your workstation is your secretary, where you have your computer and the printer. That is your workstation. It's like robotistancy. I don't know if you use robotistancy or robotimisted is the place where only one works. Whereas workplace, work zone is wider and includes several workstations. So, and you mix that, but I understand it's difficult because Ukrainian does not have this. In this case, I think it's difficult, and that's why you mix. Sometimes you put workplaces where is workstations. Sometimes you put workstation where is workplaces. So, doesn't matter what you call it. Since you understand what you are talking about, and the meaning is workstation is for one worker, workplace is for several. That's the logic that you have to keep in mind. Thank you, Pedro. Over to you.
I would say only one thing, because I subscribe everything you have said. So I have nothing else to say, unless one small thing. So I will say that I maintain my remarks in terms of difference of the word workers, workplaces. Antonio has already explained that, dust, dirt, etc. But you know, the labor inspectors and the enterprises and the workers will deal not only with them, but with lawyers in the courts. If you don't have a coherent, systematic, and holistic diploma in terms of set of diplomas in terms of health and safety, it will be very easy to lawyers to play with the words between workplaces, workstations, hygiene, works, dirt, substances. You have to arrange a coherent, a substantial set of diplomas that could interplay between them in order to facilitate the enforcement of the diplomas, but also to make it easier to the labor inspectors and the workers and their representatives to comply with the diplomas and to enforce the diplomas. Otherwise, you will have biggest problems with lawyers and courts. A labor inspector could impose a fine, a process in a workplace or a construction site with huge problems in terms of health and safety. And when it arrives to a court, the lawyer could say, well, it's not a question of hygiene, but it's a question of health and safety. Or it's not a question of substance. It's not substance. It's dust or dirt. And they play very well with the words. If you have a set of diplomas that don't match with them inside of them within their set of diplomas, you will have huge problems to enforce this kind of diplomas. Well,
so thank you, Pedro.
I have a question to you, Antonia. In Portugal, is there the decision of the government on minimum requirements to OSH at construction sites?
I didn't understand the question. In Portugal, what?
OSH requirements to construction site. What is the act that regulates that? Is that a governmental resolution or what's the status?
You know it by heart, no, Pedro? Do you remember the number?
A decree law. 270.
That transpose the directive.
Yes. Which directive? 57 or 309?
Yeah, the 57.
It's a decree from the government, 273, 2003. It's with the authorization of our parliament. If the government have set a diploma with the authorization of the parliament. The parliament in Portugal is the main body who draw up diplomas.
And by the way, the OSH draft law in Portugal was transposed by the law 107, right? The last version, 107, law 107 of, help me, Pedro. I don't.
What law? In construction sites?
No, OSH.
The 391.
Yes, the 391. Law 107 of 2012,
yes,
the last version.
The changing of the original law.
Yeah. It was transposed by a law in 89, right?
Yeah.
89. And then the last version is a law 107, because in Portugal,
original law.
The OSH directive is transposed by a law. And the individual directives are transposed by government decrees, which is the second level of importance, but only with authorization of the parliament. The parliament has to give a specific authorization to the government to regulate areas of employment and OSH.
Yep.
Okay. Any other question? I don't see any questions from our colleagues of the Zoom. Are they sleeping or what's going on? Are you alive? Do you have any questions?
I've been massaging our colleagues on Zoom, like raise your hand or ask questions, but I see no feedback so far.
For the colleagues in the room, do you have any additional question for us, for Pedro in particular? So if there is none, and if you need more time to think about it, you can always get to Pedro this afternoon, because he will be here with us to discuss the technical recommendations on the SLS draft law proposal on safety, minimum safety and health requirements for workplaces. For now, I will give the floor to Sophia to give you some maybe to Alexander Ignatov for some closure remarks. Then I will make some closing remarks, and then Sophia Letven will address some housekeeping message for you. The floor is yours, Alexander.
Thank you, Antonio. I believe that this session has been very helpful, useful for us all. A lot of things have become clear because the directive seems to be rather short, concise, and quite straightforward. But then when you try to transpose that to our legislation, you do encounter a lot of questions. Some have been addressed. We will come up with a draft that we will actively discuss with social partners. Of course, this is a must, and we will have a more detailed discussion after this meeting, because we have heard a lot of things that will help us to move forward there. The draft resolution, as it is recommended by the colleagues, I believe we already have the first version of that document, but after that, this session, we will need to amend it, and we will further discuss it with social partners. We had very efficient exchange when we prepared methodological guidelines, recommendations that have not yet been adopted with the new law, though. So then we had this productive, efficient exchange, and then when we submitted it to the cabinet, we already had a more or less comprehensive draft. I believe that for construction sites, we need to do the same. Thank you.
So I would say that it was a very productive discussion. Of course, if you have any other questions, you can forward to SLS, to Alexander, or to the EU-ILO project, to me or to Sophia Letven, and we'll try to address them. I would point out that, as Alexander said, EU directives are very straightforward, and they have two other characteristics. They are mindful of the results, not of the processes. They are focused on the result that is obtained, and they leave room for each country to decide how to get there. But I also learned, I'm here in Ukraine for almost 4 years, and I learned that Ukrainians want to have it all written down. Who does what, when, at what time, if it is day or night, if it is Monday, Tuesday, when. You like to have all things detailed on law. There are things that make sense to have detailed on law. One of those was raised here today. It is the profile of the coordinators in the phase of project or in the phase of execution. That makes sense. We made that mistake in Portugal, and we are still trying to correct it. So if you can avoid to do it, so you should. Other aspect is that, for example, information, the obligation to inform, that is an obligation which is foreseen on EU law in the member states law. And the employer should provide evidences of informing workers that can. But of course, we don't say that it has to be a written document that has to contain this detailed information. What is the precise content of the document that should prove that the workers had. We don't go too deep. We don't go that deep. But it's obvious that the employer has to provide evidences of compliance of this legal provision of the obligation to inform. And we don't have to even annex a template with that evidence. No need. But in Ukraine, you have to do it. You have to define what is the template that the employer has to fill in, where the employer has to sign, where that is focused on the process, not on the results. And the results, what is the result? Is that workers are informed about the risks, about the measures, and also their representatives. That is the result that we want to achieve. That's it. So I would suggest that you try to keep it simple. And of course, there are, things that should be on the law, which the main of them are on the EU directive, plus others that are not specified, like, for example, the profile of those coordinators, that should be, of course, detailed. So without further delay, I invite you to join us after lunch for the section on the workplaces. It will start at 2:30, right?
Yes, we've got more time for our relaxation. The presentation will start at 2:30.
So thank you very much for coming. I will pass the floor to Sophia Letven, which has some housekeeping information for you, and we'll see ourselves later after lunch.
So those participants who are present here will enjoy their lunch, but people on Zoom, I'm so sorry, you will have to care about your lunch on your own. And I have some piece of information for colleagues in Zoom. I would like to share the screen and demonstrate the website, which includes all the materials pertaining to this event and all other events, but I need some help with sharing the screen. Dear colleagues, please pay attention. This is the website of our project. To get access, you have to type our web address. Then you should select Ukrainian version, and here you will see the OSH section. There, all the recommendations, so blocks of recommendations are published. Recommendations for individual legal acts and the recommendations for transposition of the framework directive. So here, for instance, today's topic, you see the recommendations. If you click on the document, you can download it. The presentation of Pedro is also here. It can be downloaded as well, and you have the links in the chat. And now I'd like to ask you, if you please fill out the evaluation forms, the feedback forms. You've got the links in the chat. There are just 5 questions. Everything is fast and easy. And dear colleagues, those in the room, please fill out these forms and provide us with your feedback. And this feedback can be provided anonymously if you wish. I think that's it. So, today, after lunch, we are going to have another session. On Tuesday and on Wednesday, 2 more webinars and workshops are scheduled. The links are in the chat. As far as I understand, our lunch will be served on the first floor. So Ina will show us the way. So let's have lunch, let's breathe some fresh air, and see you at 2 when the registration starts. As far as I understand, the majority will join us during the second session.